Nancy gives Ray what is described as a playful shove while on her way to pick up the phone. This would be considered an intentional tort. This is also considered assault. Assault is an intention and unexcused threat of immediately harmful or offensive contact that occurs verbally or physically and creates a believable threat. Physical contact isn't required for assault to occur, whereas battery is any form of harmful or offensive physical contact that is unexcused and intentionally performed. It is unlikely that Ray will even bring this case to court because he wasn't seriously hurt and they are married. However, if he was to bring this to court, he could sue for damages for libel. These are general damages. The plaintiff doesn't have to prove injury, and Ray could state emotional distress as a defense. Nancy's issue with her dry cleaning order raises potential concerns about negligence or breach of contract on the part of Superior Cleaners Incorporated. They may be liable for any damage or the loss of her sheets if it is determined that they were mishandled in her order. Negligence, as stated previously, is the failure to live up to a required duty of care that a reasonable person would exercise in similar circumstances. Since she follows all the elements of negligence in this case, it can be brought to court. Damages that could be provided to Nancy are compensatory damages. Since this case falls under the elements of negligence, then the most likely outcome of this case is for Nancy to win. This could also be considered an implied contract because their conduct created and defined the terms of the contract. The burden of proof is on Nancy to prove that she brought the sheets there. If she can do this, then she is the most likely to win. If there is no record of Nancy's dry cleaning order, Superior Cleaners may be found liable for reimbursing her for the cost of the custom-made covers. However, if Superior Cleaners can demonstrate that Nancy did not bring in the items, her claim can be disputed.
Action.
The jury has found a verdict. Nancy will be awarded compensatory damages and her sheets.
Thank God, those sheets cost me a fortune.
In this complaint, Nancy and her beauty salon, A Cut Above, are named as the defendants about employment discrimination. Ashley King was alleging that she was wrongfully terminated because she told Nancy she was pregnant. This is considered employment discrimination based on Title VII and is covered under the Pregnancy Discrimination Act. Some defenses to be considered for Nancy and A Cut Above are business necessity and bona fide occupational qualifications. Ashley was seeking $1 million in damages. This doesn't fall under business necessity because Ashley was terminated solely for being pregnant, which, as mentioned, is covered under the Pregnancy Discrimination Act. Bona fide occupational qualifications require the employer to prove discrimination against a protected class is essential to the job. This could be considered bona fide occupational qualifications if Nancy can prove that not being pregnant is essential to performing the job. However, being that Ashley performed the job prior to being pregnant and was only a receptionist instead of a very physical job, it's likely Nancy won't be able to claim not being pregnant as a BFOQ. If Ashley can show a pattern of pregnancy-related discrimination in the salon, or specific instances where Nancy acted against her because of her pregnancy, it could strengthen her case. In this case, the most likely outcome would be for Ashley to win because she has all the elements for employment discrimination. The jury has come to a verdict. Nancy is guilty, and Ashley will be rewarded $1 million.
I didn't like her anyway.